On behalf of the Iowa Lawyers Chapter of the Federalist Society, welcome. My name's Sam Langholz, and I'm the president of the Iowa Lawyers Chapter. In my day job, I serve as Iowa's state public defender. For those of you unfamiliar with the Federalist Society, we're a nonprofit, nonpartisan organization with a long history of promoting debate and discussion about important legal issues of the day. The Iowa Lawyers Chapter was founded about 2.5 years ago to help foster that mission here in Iowa. And tonight, we're excited to be hosting one such discussion, healthcare reform in the Supreme Court, an insider's perspective on the historic constitutional challenge to President Obama's healthcare legislation. Our speaker is Greg Katsas, a partner at the Jones Day law firm in D.C., who serves as co-lead counsel for the private party plaintiffs challenging the Affordable Care Act in Florida, the 11th Circuit, and eventually in the U.S. Supreme Court. Mr. Katsas argued in the Supreme Court on behalf of the private plaintiffs on the first day of the marathon 3 days of oral arguments last month. Mr. Katsas argued on the jurisdictional issue of whether the Anti-Injunction Act barred the challenge to the Health Care Act. Mr. Katsas has a wealth of appellate practice and civil litigation experience. He's a graduate of Princeton University and Harvard Law School. He clerked for Judge Edward Becker on the Third Circuit before serving as a law clerk to Justice Clarence Thomas on the D.C. Circuit and again in the U.S. Supreme Court. In fact, as I was reading Justice Thomas's memoir a few weeks ago, I learned how Justice Thomas describes that Mr. Katsas was the person who informed Justice Thomas that Thurgood Marshall was retiring from the Supreme Court, from the seat that eventually Justice Thomas took, and also passed on the phone call from the White House, or rather I think from Kenny Buckport, that eventually resulted in Justice Thomas's appointment to the Supreme Court. Mr. Katsas has served in various senior positions with the U.S. Department of Justice, including serving as the head of the Civil Division of the DOJ. He's argued more than 40 appeals and has argued in every federal appellate court in the country, including his most relevant tonight in the Supreme Court. Please join me in giving a warm welcome to Greg Katsas. Thank you.
Thank you, Sam, and thanks for having me, and thanks for such a great turnout. I thought what I would do is first just sketch out for you the basic constitutional argument that we presented to the Supreme Court a couple of weeks ago, challenging the Affordable Care Act, and then speak a little bit more generally about the case and the oral arguments and where we are and where we may be headed. So the Affordable Care Act is, of course, a very long and complicated statute. It's about 2,700 pages long, but the constitutional challenge really focuses on one very narrow, very specific provision, which is called the individual mandate, and that is the requirement that essentially every American citizen, beginning in 2014, maintain a government-specified level of health insurance. We think that gives rise to a novel and profoundly important constitutional question, which is whether Congress has authority under Article 1 of the Constitution to force Americans, consumers, to buy goods and services that they don't want. The government has asserted 3 different possible sources for this authority in what I think are probably decreasing order of plausibility and importance. They assert this power under the Commerce Clause, under the Necessary and Proper Clause, and under the taxing power. So let me address briefly each of those in turn. First, the Commerce Clause. Like any good Federalist, I will start with the text of the clause, which gives Congress the power to regulate commerce among the several states, or interstate commerce for short. That gives rise to the question, what can plausibly be described as regulating interstate commerce? we think basically two things. One is that Congress can prohibit interstate commerce that it doesn't like. The federal drug laws are a classic example of that. Congress doesn't want interstate trafficking in marijuana, cocaine, and so on, so they pass laws prohibiting that. That's one kind of regulating interstate commerce. The other kind of regulating interstate commerce is to paraphrase Chief Justice Marshall from the Supreme Court's very first Commerce Clause decision. They can prescribe the rules for carrying on interstate commerce. That's not forcing anyone to engage in interstate commerce. It's saying that if you do choose to participate in commerce as a buyer or a seller, here are the rules that you have to follow. So again, just to take a couple of obvious examples, a classic example of New Deal era Commerce Clause legislation of this type would be a minimum wage law, right? If you're engaged in labor markets as a buyer or a seller, you can't have those transactions at less than the hourly rate that Congress specifies as the minimum. Or to take the classic example from the Civil Rights era, if you are engaged as a supplier in any kind of public accommodation, hotels, restaurants, whatever, you must take all comers. You can't turn people away based on race, sex, religion, and so on. It's not forcing anyone to become a supplier of hotels or restaurants. It's just saying if you choose to go into that business, those are the rules you have to follow. Neither of those sort of classic examples of Commerce Clause authority describe what Congress is doing here, which is not prohibiting commerce that it doesn't want, and nor is it prescribing the rules for carrying on commerce. It is forcing people to engage in commerce. It is telling people who don't want to buy health insurance, in this case, that they must buy health insurance, and that, we think, can't really plausibly be described as Congress regulating interstate commerce. It's really Congress forcing people into interstate commerce in order for Congress to regulate them. And I'll say more in a couple of minutes about the theory of why Congress wants to regulate them. But for now, the textual point is it's not really regulating interstate commerce to force people into interstate commerce to make them the objects of federal regulation. So that's our textual argument. It is strongly backed up, in our view, by history. And that's because Congress literally has never before, in our history, asserted a Commerce Clause power to make people buy unwanted goods and services. If you think about it, this would be an incredibly attractive power for any Congress wanting to stimulate the economy in general or particular economic markets for whatever reason. So go back to the founding era. One of the most substantial problems that the framers faced was how to stand up a national economy. What better way to stand up a national economy than to simply force people to buy goods and services, domestic goods and services? And yet Alexander Hamilton writes his report on manufacturers. He's one of the most nationalist, pro-national power leading members of the founding generation, writes his report on manufacturers, lists all sorts of things that Congress can do to stimulate a national economy, and it never even occurs to him that this pretty direct and effective means of just forcing people to buy goods and services is one option available to Congress. Or fast forward to the New Deal. The country is mired in the worst economic depression of its history. Franklin Roosevelt is president. There's a New Deal Congress. Neither the president nor Congress are bashful about aggressive uses of federal power to try to bring the economy out of the depression, and yet neither Roosevelt nor the New Deal Congress even conceive of this idea of purchase mandates as something they could use to stimulate the economy, a seemingly, again, very direct and effective means of doing that if the power is available. This lack of precedent, in our view, has not only historical interest, it has legal significance as well, because the Supreme Court has said on a handful of occasions that if there is an alleged federal power that is seemingly always available but has lain dormant for our now some 230 years of constitutional history, the fact that it has never been exercised heretofore is itself pretty good reason to doubt that the alleged power exists in the first place. So that's the historical argument. We have arguments based on precedent. I'm just going to talk about one case. That's Wickard against Filburn. Some of you may remember it from law school. It is a case from the early 40s that is generally thought to be the high water mark of the Supreme Court's very expansive interpretations of the Modern Commerce Clause. So Wickard involves a farmer named Roscoe Filburn who wants to grow a little bit of extra wheat to feed his family. Unfortunately, Farmer Filburn is subject to a production quota imposed as part of a federal program to prop up the price for wheat. He challenges the federal scheme, and he says, this isn't regulating interstate commerce. I'm not engaged in any commerce. I don't want to buy or sell the wheat. I just want to produce and consume it for my own personal use. So there's no commerce, and there's also nothing interstate. I'm not selling it or even consuming it across state lines. I'm just growing it at home on my farm. And the Supreme Court says, too bad. They uphold the production quota, and they give rise to what lawyers now call the substantial effects doctrine, which is the idea that people engaged in what later cases would call economic activity, sort of a commerce light idea. It's not exchange of goods and services, which is commerce, but it is at least producing and consuming commodities. The court says people engaged in economic activity can be regulated under the commerce power even if their own effect on interstate commerce is de minimis, on the theory that, well, there are thousands, if not millions, of farmers like Roscoe Filburn. If each of them is allowed to produce extra wheat, even locally, the aggregate effect of all that extra production, of course, will have a downward pressure on prices in the interstate market, and that will frustrate the congressional objectives for the interstate markets. You can see, obviously, from that case, the incredibly expansionist tendencies in the court's cases, but for present purposes, what I'd like to stress is just how different even Wickard is from this statute, the Affordable Care Act purchase mandate. The government has tried to analogize this case to Wickard, but this is really not like Wickard. The analogy would be not of this case to Wickard, it would be of a hypothetical statute in the 40s, not that told people engaged in producing and consuming wheat, you can only produce and consume so much. That's classic regulation, maybe not of commerce, but prescribing the rules for production of commodities. The analogy of this case to Wickard would be a hypothetical statute forcing Roscoe Filburn's neighbors to buy his wheat, purchase mandate. People who don't want to be engaged in the activity forced into the market in the New Deal era. In the theory of the Filburn statute, it would be the same theory of the actual statute. We want to raise the price of wheat. What better way to do that than to force people to buy it? And yet, the New Deal era Congress never did anything like that, and therefore the New Deal era Supreme Court, neither in Wickard nor any other case of that generation, had occasion to approve of anything like the purchase mandate we have here. So what we have is an assertion of Commerce Clause authority that is unlike any one we've ever seen before. This is literally unprecedented, and the question before the Supreme Court is one of first impression, one way or the other. We think the lack of precedent, as I said, cuts against upholding the mandate. But there's more to it than that. There is also, in our view, the lack of any limiting principle. If you take the doctrine that I've just described, it would seem that the relevant question before the Supreme Court is how to apply the substantial effects doctrine of Wickard to non-purchase decisions. Now, the government, on one level, is absolutely right in the following sense, which is if you look at the health insurance market with millions of people forced into it as a result of federal legislation, that market will look substantially different from the existing free market in which the only consumers of health insurance are people who voluntarily choose to buy it. So in that sense, one could say it is true that the federal statute forcing millions of people into the health insurance market, in a sense, substantially affects the health insurance market. Now, the problem with that line of argument is if that argument works for health insurance, it works for literally any good or service you can imagine, because nothing I just said is specific to the health insurance market. Any market you can imagine with millions of people forced into it as a result of a federal purchase mandate will look substantially different from the free market that would exist without it. And this would seem to open the door to all manner of federal purchase mandates. You know, we've talked in the case about hypothetical mandates to buy cars, mortgages, broccoli, gym memberships, you name it. If the government's basic Commerce Clause argument with regard to health insurance works for health insurance, it would seem to work for just about any good and service you can imagine. And if that were true, then this purchase mandate power would literally give the Congress a blueprint for replacing what has been until now a system of basically free markets, regulation to be sure, but people deciding whether or not to be in markets by their own choice, with a command and control economy in which consumption, or at least purchase decisions, could be dictated not by the choice of millions of individual consumers, but by congressional fiat. Unless you think that that specter of a purchase mandate supporting a command and control economy is a hyperbolic exaggeration of an advocate developed for purposes of litigation, I will tell you it is not something that we made up in litigating this case. It is the very precise formulation that the Congressional Budget Office used in 1994 in discussing the proposed purchase mandate for the Clinton-era healthcare reform statute that was debated vigorously in the early to mid-90s and ultimately not passed. So, in a nutshell, unprecedented assertion of federal commerce power, which, if accepted, seems to have few, if any, discernible limiting principles. That is our Commerce Clause objection in a nutshell. Let me now say a couple of words about the necessary and proper clause. The government makes a quite distinct argument for upholding the mandate in the Affordable Care Act under the necessary and proper clause, and it runs something like this. They say, don't just consider the health insurance mandate by itself. They say you have to consider the mandate as part of a larger and broader scheme of economic regulation. And for purposes of this argument, the larger and broader scheme is the statute's restructuring of the health insurance market. And the most important provisions that do that are called the guaranteed issue and community rating provisions. The guaranteed issue rule states that requires insurance companies to accept all customers, no matter how sick they may be, no matter what their actuarial risk is. And the community rating rule requires insurance companies to charge all customers an average price that does not reflect the individual actuarial risk of particular insured individuals. So Congress says, well, what will happen if, oh, and I should say, we do not challenge guaranteed issue and community rating under the Commerce Clause, because on our theory, that is not forcing people into health insurance markets. That's just prescribing the rules for carrying on commerce in the health insurance markets. So any direct challenge to the guaranteed issue and community rating rules would require a wholesale rollback of modern Commerce Clause precedent, and we did not take that on. So we take guaranteed issue and community rating as a given. The government says, well, that system of regulation won't work well without an individual mandate. Why? Well, what's going to happen? What are the economic incentives under a system like that? This is not my view of what's going to happen. This is Congress's view as reflected in its legislative findings and as reflected in testimony by advocates of the Affordable Care Act. So what Congress thought would happen, borne out by lots of economic literature, is that low-risk individuals will simply opt out of the insurance market, right? They're getting a terrible deal for them because they are buying insurance at average risks that doesn't reflect their low risk. The whole point of this is to force insurance companies to subsidize the high-risk individuals who are getting a great deal because they're getting insurance at average rates that don't reflect their high risk. Okay, that's a terrible deal for insurance companies. They will predictably lose huge amounts of money in insuring high-risk individuals who are given a utility-like entitlement to get a service at an average price. And the quid for that quo, to sort of help the insurance companies make up the difference, is to give the insurance companies a great deal with respect to the low-risk individuals. Low-risk individuals vis-a-vis insurance companies, it's a great deal for the insurance companies, it's a terrible deal for the low-risk individuals. That's a quid pro quo from the perspective of the insurance companies, or you can think of it just in terms of the insurance pool as Congress forcing the low-risk individuals to subsidize the high-risk individuals. That's the way the economics of the thing work. If you don't have the purchase mandate, what happens? Well, the low-risk individuals opt out of the market and just self-insure and make their own arrangements. That causes the pool to get riskier. That puts upward pressure on prices, and the upward pressure on prices frustrates one of the congressional goals, which is not only access to insurance, but affordable care. Drives up the price of health insurance. Some witnesses before Congress even described the likely result as, in their words, not mine, a death spiral in the insurance industry. And this is borne out to some extent by the experience of states which had tried guaranteed issue and community rating without a purchase mandate. So Congress says, well, look, we need the purchase mandate to make the system of regulation work. And therefore, it's appropriate under the necessary and proper clause. So what's wrong with that argument? Well, in our view, this is a fundamentally different sort of justification than we've ever seen before under the necessary and proper clause. The necessary and proper clause authorizes Congress to enact legislation necessary and proper to, these are the exact words in the clause, carry into execution one of its enumerated powers, in this case, the Commerce Clause. So what that typically has meant is Congress can enact some sort of ancillary rule, for example, to enforce its Commerce Clause regulations. So if Congress imposes requirements on business or whatever that are difficult to police, to take a classic example from the New Deal era precedent, Congress can impose record-keeping requirements on businesses that facilitate enforcement, that make it easier to ensure that the businesses will follow the Commerce Clause regulation. Or to take another example from a recent Commerce Clause case involving medical marijuana, Justice Scalia wrote a noteworthy opinion in which he says that the justification for a federal prohibition on local possession of drugs like marijuana, even if for medicinal uses, is under the necessary and proper clause, because he says, well, you know, local possession is not regulation of interstate commerce, but it is necessary and proper to make the ban on interstate commerce in marijuana effective. Why is that? Well, marijuana is fungible. It doesn't come with little tags, you know, for medicinal use only. If you allow people to possess marijuana locally for medicinal use, it's never a moment away from diversion into interstate markets. And so he says the local possession ban is necessary in that sense to enforce the prohibition on interstate commerce in marijuana. Those sorts of justifications are very different, in our view, from the justification here for the purchase mandate to make guaranteed issue and community rating work. Here, there's no problem with enforcing guaranteed issue and community rating. Congress's concern here is not that those provisions won't be carried into execution, to use the exact phrase of the necessary and proper clause. Their projection of a problem presupposes that the guaranteed issue and community rating regulations have been fully executed, that the insurance companies are complying with those regulations, and what they are really saying is that those regulations are hugely burdensome on the market participants who are the object of the Commerce Clause regulation, and therefore Congress says they need what we describe as kind of an offsetting power, the power to dragoon strangers to the regulated market and force them into the market so that Congress can offset the regulatory costs that it has otherwise permissibly imposed on market participants. And that idea as well, this idea of an offsetting power extending to non-market participants for purposes of the Commerce Clause is equally novel. We don't know of any case in which Congress has used this sort of theory to justify a necessary and proper power ancillary to its Commerce Clause power. And like the basic Commerce Clause justification, this one as well seems dangerously unbounded and limitless. So just to give you a couple of examples of that, go back to Wickard against Filburn. Congress has prevented farmers like Roscoe Filburn from growing as much wheat as they would like. That's a regulatory burden imposed on farmers, people like Filburn. Can Congress offset those burdens by forcing Filburn's neighbors to buy his wheat? One would think not, based on history and based on the Commerce Clause arguments that I ran through, but if this offsetting power works here, presumably the same sort of rationale would apply there. Or take the civil rights era type cases. Congress imposes non-discrimination requirements on folks who run hotels and restaurants and so on. In the South, in the 60s, when the Civil Rights Act was enacted, a lot of businesses opposed those laws on the ground that this would be very bad for business because many of their clientele would not enjoy dining in an integrated restaurant. And unfortunately, at that time and place, that was probably an empirically true prediction. So the public accommodations, anti-discrimination laws impose burdens on the people who are voluntary participants as suppliers in the market, right, the people who run the restaurants. Can Congress offset those burdens by forcing the rest of us to dine out at restaurants? Or take the Affordable Care Act itself, as I've described the economics of how Congress thought the system would work. Congress is providing a subsidy to high-risk individuals to facilitate their purchase of insurance. That imposes costs on the rest of the system, on the insurance companies and the low-risk individuals. Can Congress offset those costs by requiring either the high-risk individuals or more likely just simply everyone to buy all of the healthy goods and services that will, on average, lower healthcare costs imposed on the system, the broccoli and the gym memberships and such? Again, one would think not based on our history and tradition, but if the government's offsetting theory is right, it's hard to see why that wouldn't work. So ultimately, our necessary and proper arguments come down to the same basic themes as our Commerce Clause arguments: novel assertion of power, unlike anything we've ever seen before, which, if accepted, seems to admit of few, if any, limitations. That brings me to the last of the government's three asserted sources of power for the individual mandate, and that is the federal government's taxing power. This is, I think, the government's most difficult argument, simply because while one can imagine statutes similar to the Affordable Care Act structured as taxes, in fact, the mandate from the Affordable Care Act is not structured as a tax. The Supreme Court's cases on the government's taxing power give the government a lot of leeway to tax. What's a tax? A tax is a forced payment imposed on some lawful voluntary activity in order to support the government. That is different from what the cases describe as a penalty. A penalty is a forced payment to the government imposed as a consequence of the violation of some independent provision of law. So just to make that concrete, take an example, cigarettes. Congress can tax the sale of cigarettes. That doesn't make it unlawful to sell cigarettes. It's, if you choose to sell cigarettes, you have to pay a tax of $5 a pack, let's say. That is different from a requirement or prohibition backed up by a penalty, which would be Congress chooses to outlaw the sale of cigarettes and then impose for violation of that legal requirement a penalty of $5 per pack on cigarettes. And what the Supreme Court's cases say is Congress has incredibly broad latitude when they are imposing taxes on voluntary lawful activity. The cases say the court will not look behind a tax imposed on voluntary activity to figure out whether it was motivated by some regulatory purpose or whether the effect of the tax is regulatory, right, to drive people away from the taxed activity. But one constant requirement in all of that jurisprudence is that in order to have a tax, Congress has to impose the tax on lawful activity. What always makes a tax into a penalty is if the exaction is imposed for violation of some separate provision of law. So that's the basic jurisprudence. How does the mandate work? Okay, was it something I said? I guess I got that wrong. It's structured as a prohibition backed up by a penalty. The mandate, or sorry, a requirement backed up by a penalty. The mandate by its terms, by its mandatory terms, is a requirement to maintain health insurance at a government-specified level. And there is a separate provision in the statute imposing a penalty, a payment to the government for violation of that requirement. So the requirement to maintain health insurance itself obviously is not a tax. To the extent it entails payment of money by the regulated entity, it's not even payment of money to the government, it's payment of money to the an insurance company to acquire the requisite good or service, nor is the payment to the government made by people who violate the mandate a tax. Why not? Well, because that's a payment exacted precisely because of a violation of the requirement to maintain health insurance. That's what the text of the statute says. Though that aspect of the statute is strikingly different from other parts of the Affordable Care Act, which are structured as taxes on voluntary activity, including what is loosely described as the employer mandate, which is a provision that says to employers that allows employers to not provide health insurance to people, but says if you make that lawful choice, then you have to pay the government a certain exaction, which is described in the statute as a tax. So that's a pretty striking contrast, right? For employers, it's labeled a tax, and it functions as a tax because it's a payment made as a result of a voluntary choice on lawful activity, in contrast to the employer mandate, which is labeled a penalty and functions as a penalty for reasons I've just said. That's the taxing point. Now, I think one measure of how far we've come in this case is that at the outset of the case, the government would have vigorously disputed everything I just said. By the time we got to oral argument in the Supreme Court, the government had either affirmatively conceded much of what I just said or has offered, at best, somewhat tepid opposition to it, as in the case of their continuing assertion of the tax argument. What they have done is narrowed their position to the idea that even if everything I just said is right as a general matter, they say healthcare is different. And they say healthcare is different for a bunch of reasons, empirical descriptions of the way healthcare and health insurance markets work economically. They say the healthcare market is unusual for some combination of the following reasons. Almost all of us at some point either have consumed or will consume healthcare. They say that the cost of healthcare can be prohibitively expensive. Many, if not most of us, can't afford to pay for healthcare out of pocket, particularly if we suffer some catastrophic injury or disease. They say that the incurrence of that sort of catastrophic injury or disease is entirely unpredictable. They say that when people do suffer some sort of catastrophic injury or disease, they are provided health care services regardless of ability to pay, in particular in emergency rooms as a result of federal and state law. And finally, they say as a result of those sorts of legal requirements, when someone goes into an emergency room uninsured, consumes the health care services, and either can't or won't pay for them, the doctors and the hospitals are left to absorb the cost of those services, and of course, they, to whatever extent the supply and demand curves allow, they pass on those expenses to other consumers and other insured individuals, and the rest of us end up paying more as a result of that. uncompensated care in emergency rooms. And they say for some or all of those reasons, health care and health insurance are different, and therefore a decision upholding this particular purchase mandate with regard to health insurance won't necessarily give rise to the blueprint for the command and control economy, as the CBO had warned some years ago. So what's wrong with that argument? Couple points. First of all, this isn't so much a legal argument, but it seems to me at least worth noting that it's a little bit ironic for Congress or for the government to assert a professed concern with cost shifting in order to justify the mandate. They focus on the cost shifting that arises from uncompensated care in emergency rooms, but the whole point of the mandate, as I've described it, not on my view, but on Congress's, is not simply to facilitate, but to affirmatively compel cost shifting in the insurance pool from low-risk individuals to high-risk individuals. And while one can differ on the exact magnitude of all of that cost shifting, the congressionally mandated cost shifting in the insurance pools dwarfs the cost shifting, the emergency room cost shifting that is the asserted cause of Congress's concern, at least by an order of magnitude. So there is some reason to wonder whether this particular asserted justification may be somewhat pretextual. Second point, the government's asserted distinctions of healthcare and health insurance markets are not that sharp on the facts. At most, they have an argument that this market may be somewhat different in degree when you take all of the considerations and put them together, but none of these distinctions really is all that sharp, right? The unpredictable nature of certain healthcare services, well, we typically purchase insurance against all sorts of unpredictable occurrences, not simply with regard to healthcare, but floods, disability, burial insurance. So at a minimum, the government's theory wouldn't seem to distinguish any kind of services market for which there is insurance. Free riding and cost shifting, yes, it happens in emergency rooms, no question about it. But is it limited to healthcare? Well, no. It really happens anytime any individual buys a good or service on credit and then defaults. So the government made a big point in its brief of highlighting the fact that one of our private clients, unfortunately for her, filed for bankruptcy during the pendency of the litigation, had about $4,500 in unpaid medical bills, and the doctors who were the unsecured creditors of those bills presumably didn't get any money for their services. That's unfortunate, it's true. But what the government didn't say was that there were $45,000 of other unpaid bills to everyone from the landlord to the cable company, and none of those creditors were fully paid for their services either. The idea that federal law somehow facilitates the cost shifting, right? The government says federal law makes health care services available, at least in emergency rooms. But the bankruptcy law itself facilitates cost shifting, because when my client filed for bankruptcy, federal law facilitated the stiffing, as it were, of all of her unsecured creditors. So that doesn't seem to sharply distinguish healthcare or health insurance markets. And finally, the idea that healthcare services are provided to individuals, needy individuals, for free, regardless of ability to pay. Well, most modern liberal societies, including ours, provide a lot of goods and services to needy people, regardless of ability to pay. Not simply healthcare, but food, shelter, clothing, transportation, legal services, just to name a few. So that consideration doesn't seem to sharply distinguish healthcare and health insurance from any other market. More fundamentally than any of that, though, is the point that even whether or not the government is right that the healthcare and health insurance markets may be factually and empirically different, at least in degree, given all of the combination of reasons that they lay out, none of those considerations seems the least bit legally relevant, at least under existing doctrine. So the Commerce Clause question, as I framed it in the first part of my comments, seems to be the question how this aggregation principle and substantial effects doctrine applies to non-purchase decisions. The necessary and proper clause doctrinal question seems to be whether Congress has this sort of offsetting power. Does that count as carrying into execution the federal power? None of those doctrinal questions turns the least bit on the government's empirical and economic characterizations of the healthcare and health insurance markets. So it's hard to see the legal relevance of any of it. Now, one might say, well, the Supreme Court is the Supreme Court. They can write an opinion any way they want. So why can't they just take the government's empirical and economic distinctions of the healthcare market, assuming they are distinctions to begin with, and just constitutionalize them and say by fiat, this is the new constitutional rule. Purchase mandates are fine for healthcare and health insurance markets because those markets are different for some combination of the following 5 economic reasons. I suppose they could write that opinion, but if they uphold the health insurance purchase mandate, you can rest assured that that will not be the last purchase mandate that Congress enacts. So ask yourself what happens with respect to purchase mandates numbers 2 and 3 and 4 and 5 and so on, where Congress no doubt will be responding to some perceived national problem, be it in the market for cars or mortgages or whatever, and Congress will have some sort of economic justification about why they need a purchase mandate, why there aren't other available means of regulations, why this market may be more like the healthcare market than like the broccoli market, right? You can imagine all of that playing out. If those mandates are challenged and they go up before the Supreme Court, having written the kind of opinion I'm positing, what does the Supreme Court do in all the later cases? Well, they do one of 2 things. They either throw up their hands and say, look, we are not going to second guess congressional judgments about the importance of the government interest, the economics of the way the market works. We are only reviewing not to decide whether Congress got something right, but only to decide whether there was a rational basis for the congressional legislation. This is a strand of Commerce Clause jurisprudence. If they go that route, then purchase mandates 2, 3, 4, 5, and so on will be routinely upheld with relatively perfunctory opinions deferring to congressional judgments about the next market and the next market and the next. And so the slope may not be automatically slippery as a matter of law, but in practical operation it will be slippery because that's just the way judicial review will work. That's one possibility. The second possibility is that the Supreme Court will really take it upon itself to make its own de novo judgments about the extent to which the hypothetical car market may be more like the healthcare market than like the broccoli market or some other market, make its own judgments about how important the government interest is, make its own judgments about how the economics of the market work, make its own judgments about whether Congress has available alternatives. If they go that route, that is heightened Commerce Clause scrutiny, and that in and of itself would be revolutionary in a post-1937 world. That is not something the court is particularly good at. It's not something I think they would want to become involved in, but that is what they would have to do in order to enforce limits. That seems to us very unattractive from their perspective, very unlikely to work just in terms of thinking how judicial review, when it works well and when it doesn't. So we think the far preferable course for the court would be to adopt our very clean, simple, bright-line rule, which is no purchase mandates under the Commerce Clause. And it is a very narrow and conservative rule in the following sense, which is precisely because there has never before been a federal purchase mandate, the bright-line rule that we've proposed would imperil no prior Supreme Court decision and no prior or existing federal statute other than the Affordable Care Act, precisely because the Affordable Care Act is so novel and unprecedented. And all of that would avoid the court having to get into this sort of business of trying to distinguish one market from the other along the lines that the government does. That's our argument in a nutshell. Let me tell you a little bit about the Supreme Court arguments from a couple of weeks ago, and then I hope have time for questions. It would not be an exaggeration to describe these arguments as historic. The court set 3 days of argument over the course of 6 hours. Oral argument in the Supreme Court is typically 1 hour. In extraordinary cases, one might get an hour and a half or 2 hours. In the campaign finance case that was sort of singularly important and complicated in the last 20 years, courts set that for 4 hours, but that was a case in which there were some 20 different provisions at issue and a dozen different petitions. Our case basically has really two constitutional provisions at issue. I'll say a word about the other one in a second. And 3 cert petitions, 6 hours of argument, the longest oral argument in some 50 years. They basically did that excuse me, by taking a single case with 4 issues in it and converting it, treating it as if it were 4 cases, ordering separate briefing and oral argument on each of 4 major issues. So everything I just told you about the constitutional challenge to the individual mandate is really just 1/4 of what they heard argument on. The constitutional challenge to the mandate was the subject of a 2-hour oral argument on Tuesday, now I guess 3 Tuesdays ago from yesterday. That was preceded by a 90-minute oral argument on Monday, which I had the great pleasure and privilege of being part of, on the threshold question whether our challenge to the mandate is barred by a statute called the Anti-Injunction Act. The Anti-Injunction Act prohibits pre-enforcement challenges to federal taxes. For all of the reasons I explained to you why we don't think the mandate can be supported as an exercise of Congress's taxing power under the Constitution, we think our challenge to the mandate is not also a challenge to a federal tax within the meaning of the Anti-Injunction Act. Interestingly enough, the government supported us in saying that the Anti-Injunction Act doesn't bar this lawsuit. It's interesting for 2 reasons. One is the government is the sole statutory beneficiary of the Anti-Injunction Act, and one would think they have a strong programmatic interest in having the Anti-Injunction Act broadly construed rather than narrowly construed. And number two, there is no small degree of tension between the government's position that the mandate is a tax for constitutional purposes but not a tax for Anti-Injunction Act purposes. There are ways to reconcile those provisions, but the government was forced to make some very fine distinctions and open itself up to at least a perception that it was being somewhat opportunistic in saying, well, you know, it's a tax on Tuesday when we want it to be a tax, but not on Monday when we don't want it to be a tax. The court appointed an amicus curiae to defend the proposition that the Anti-Injunction Act applies. There's an argument that the statute may be jurisdictional, so the court wanted that position represented, even though the government was unwilling to represent it. The amicus seemed to get no traction in his argument, and while I'm generally loath to make too many predictions, I will say it seems pretty likely that the court will get over the AIA hurdle and will decide the merits of our constitutional challenge one way or the other. So that's Monday. Tuesday was the merits. Wednesday was two separate arguments. Wednesday morning was a 90-minute argument on severability. That's the question of what happens to the rest of the Affordable Care Act if the mandate is struck down. Again, on severability, as with AIA, the government's position was perhaps somewhat surprising. Usually the government likes to say that provisions are severable. That's the way they preserve as many parts of as many federal statutes as they can. But here, to their credit, in my view, they agreed with us on severability, at least with respect to guaranteed issue and community rating. The government, I say to their credit because this is really the logical conclusion of their argument on the merits. On the merits, they say one reason to uphold the mandate is that it is necessary in order to make guaranteed issue and community rating work. I've already addressed that argument on the merits, but for purposes of severability, you know, if that's your view of how the provisions relate, then it should be the case that if Congress can't have the mandate, it wouldn't have wanted the guaranteed issue and community rating provisions that in Congress's view wouldn't work without the mandate. And the government is consistent on these points and agreed with us, therefore, that if the mandate is struck down, the guaranteed issue and community rating provisions have to be struck down as well. The 11th Circuit, notwithstanding the parties' agreement on at least that aspect of severability, struck down the mandate but upheld everything else, including guaranteed issue and community rating. The court wanted that position represented as well, so they appointed a second amicus curiae to defend the 11th Circuit's holding on severability. He didn't seem to get too much traction for a rule of complete severability, and so I suspect if the mandate is struck down, the more interesting sort of fault line will be between us and the government saying, strike down guaranteed issue community rating, but preserve everything else. We, of course, say strike down the entire statute. That's obviously a big ask, but if ever there were a statute that was a seamless web of trades with all manner of quid pro quos woven throughout the fabric of the statute, it seems to us this is it. There are political and procedural reasons for thinking the statute is non-severable. When the statute was enacted in the Senate, the majority party supporting it had a filibuster-proof majority. They lost that majority as a result of a special election. So the House, in order to get a statute, literally could do nothing other than pass the Senate bill. Faced with that political reality, the House enacted a special rule prohibiting any discussion of amendments and forcing an up or down vote in the House on the Senate bill. That, in our view, is Congress's own declaration that they, for their own purposes are stitching this entire thing together, and that it has to stand or fall as a unitary whole. If Congress itself treated it that way for their purposes, it doesn't seem to us unreasonable for the court to treat it that way on judicial review as well. So that's severability. And then Wednesday afternoon, there was a wholly separate constitutional challenge to a different part of the Act, the Medicaid expansion. This was brought by the states who are not my clients. I represent all of the private challengers, but I'll just tell you briefly. The states challenged the Medicaid expansion as unconstitutional under the spending clause. This is the quite interesting and unsettled question whether there is any limit on Congress's ability to attach strings to federal funds. As a general matter, Congress has a lot more leeway to not to force you to do things, but to bribe you to do things by saying, look, if you accept federal money, you have to do the following things as a condition of getting the money. That's what Congress did with regard to the states on Medicaid. The states say, well, that's fine as a general matter, but there has to be some point at which the strings become so coercive as to be effectively a requirement and therefore not a proper exercise of spending clause authority. That issue in and of itself would be one of the most important cases of the term, and in somewhat more normal circumstances would have been sort of a highlight of the term. It's really sort of striking that in the context of this case that was kind of an afterthought. But that was the subject of a 60-minute argument Wednesday afternoon. States have a tough argument there, but they seem to be getting some level of interest in the court. We were very happy with how the arguments went from the perspective of the challengers. We thought that the lawyers on our side of the case all performed well. We did not think that the federal government lawyers performed as well as one might expect, given the extremely high standards of the Solicitor General's office and the extremely high importance of the case. They did fine, but they were not probably at the very top of their game. And while I don't think anyone can confidently or responsibly make any prediction about how the Tuesday and Wednesday arguments will come out, it did seem that at least a majority of the court understood that we had raised very significant concerns with the Act, and my guess is it'll be a relatively close decision, maybe 5-4. If we lose, it could conceivably be as high as 6-3. I doubt it'll be more lopsided than that, but I think the court is clearly treating this as a very substantial and unsettled and important question, which is more than some of our detractors had thought we would get out of them. Let me stop there and throw the floor open to questions. Yes?
I had heard that the original draft of this health care bill had a severability clause in it.
Yes.
What would be the government's reasoning or legislators' reasoning in taking it out other than what you had mentioned? It wasn't inadvertence, was it?
There is no, there was a severability clause in one of the original bill that passed the House. It was taken out of the bill that passed the Senate, and then post Scott Brown, the House was forced to pass the Senate bill or get nothing. Why the Senate took it out, I don't know. I've never seen any. I haven't seen anything in the legislative record. We scoured it pretty carefully. Some people have speculated that this was a tactical decision to sort of dare the Supreme Court, as it were, right? If you strike the mandate down, you might have to go all the way, and we don't think you'd have the guts to do that, so we won't give you this intermediate way out. That's one possibility. I honestly don't know. It seems it seems reckless, given the length and complexity of this statute, given the somewhat unpredictable nature of lots of constitutional doctrines. The idea that no one may have come up with some little glitch in the statute that would give rise to some localized constitutional problem, the idea that you could confidently predict that in advance just seems sort of crazy. The Dodd-Frank bill, which was the other hugely complicated signature achievement of President Obama and the 2008 to 2010 Congress, passed, I think, within a couple of weeks of the Affordable Care Act, and that one does have a severability clause. So you have this very interesting sequence. The original bill had one, Dodd-Frank has one, but the Senate bill on Obamacare does not, and we're not quite sure why. But that was one of our arguments against severability, which is they had it in there, they took it out, and that gives rise to not a conclusive inference, but a pretty strong inference that you should give that change meaning.
Follow-up question, could the Supreme Court nonetheless combine the overturn to this certain section?
They could. Neither the presence nor the absence of a severability clause is dispositive. The fact that it's not there certainly helps us. The fact that there was one in the original House bill and it was taken out helps us even more, but it doesn't get us all the way there. They will still have to consider their severability doctrines and apply them to the statute as they see fit. Thanks. Sorry, and back and next.
Is there any importance to the court and particularly the Chief Justice that this not be a 5-4 decision and rather be, you talked about 5-4, 6-3.
Right.
Does that enter in at all to this, do you think?
A lot of people have speculated that it may. I hope not. My own view is that each justice should just call it as he or she sees it, and not make essentially political judgments about how it may be received. I mean, if you're a justice on the Supreme Court of the United States and you genuinely think that a statute is unconstitutional, it seems to me you're duty-bound to vote to strike it, just as you would be duty-bound to uphold a statute that you think is constitutional. So I hope they don't go that way. Can I definitively rule it out? Probably not. I think it seemed from the oral argument that, if we win, it won't be by a margin greater than 5-4. So we could win 5-4, we could lose 5-4, we could lose 6-3. People have speculated that if we were to lose 5-4, maybe the justices in the middle would think, well, okay, the result is going to be what it's going to be. That's a given, so better for the country that it be 6-3 than 5-4. That's possible. If we lose 6-3, I hope it's because 6 of them think that the darn thing is constitutional, not because they're voting on that basis, but who knows? Yeah.
Shortly after the oral arguments in this case, President Obama had some statements saying that overturning this law would be unprecedented and that'd be an extremely activist decision. Be interested in your response to those statements on the merits, and also perhaps more broadly, the meaning of a president essentially challenging the Supreme Court in that way while they're deciding a case.
I think they had a couple of different formulations. Some of the broader formulations were frankly buffoonish. I mean, the challenge to the very notion of judicial review under the Commerce Clause, of course, is crazy, and they quickly backed away from that, and when they were asked to make a submission to the Fifth Circuit explaining the remarks, they pretty emphatically disavowed that. You know, I think there's a narrower spin of saying, look, courts owe Congress a great deal of deference, and there aren't a lot of post-1937 cases striking statutes on Commerce Clause grounds. In fact, there are only 2. And, you know, as narrowed, the position was probably defensible on the merits. As originally articulated, it was not. In terms of the president vis-a-vis the Supreme Court, I doubt they were trying to influence the Supreme Court. If that's what they were trying to do, they were remarkably stupid. This would either have no impact or it would have the opposite impact with the, you know, the justices getting their gander up, being lectured to by a co-equal branch with regard to their constitutional function. I suspect it's much more that they concluded that they may well lose on the mandate, and this is an opening salvo of a political strategy to run against the Supreme Court, as opposed to an attempt to influence their decision. Yes, sir.
I guess my question is, really we're talking about a small percentage of U.S. citizens that do not have health insurance.
Right.
Will the Supreme Court take into account when they start arguing about the mandate for a small percentage of people here in the United States?
I'm trying to think of how that might be relevant. I mean, it strikes me as more of a policy question than a constitutional question. We did try to sort of make the point that this is a wholesale kind of massive federal takeover of healthcare and health insurance markets in a way that is not justified by the problems that Congress claims to be addressing. Now, most of that plays out in the context of these arguments I sketched out about cost shifting in emergency rooms, but it equally could play out with your point about, you know, there may be a problem of underinsurance, but it's a problem on the margins. It's not a problem with the healthcare system at its core. One way in which that may play out is one of the arguments asserted against us is that Congress could have accomplished many of its objectives through alternative statutes that expanded Medicare or Medicaid, that provided insurance to more needy people. We think those arguments don't actually cut against us, they support us. And here's why. The fact that Congress can do something under one power doesn't mean that it can automatically do something substantially similar under a completely different power. If you worry about consequences, the consequence of our winning is not that Congress is disabled from providing health insurance or health care to needy people, which is fundamentally the problem here. Congress could do that through its taxing and spending powers, as it has done with respect to Medicare for some 50 years without constitutional challenge, as it has done under Medicaid without constitutional challenge, you know, subject to the challenge to the expansion for reasons particular to the expansion. There are lots of Medicaid expansions that would be unquestionably constitutional. So in our view, they could address this whatever marginal problem there is with regard to the uninsured. The reason why they didn't is, you know, the normal way you do that is you have a federal program and you appropriate funds, you know, you raise taxes to pay for it. And there's a program on the government's books, and people can make judgments about the value of the benefits it's providing and the cost of it in taxes, how well it's run, and so on. That's the way we provide public goods and services. The problem is they didn't have the political will to pass the tax increase. When the mandate was structured as a tax increase to pay for people to get insurance, they didn't want to pass that. That's not a failure of constitutional structure under our theory. That's just a failure of political will. Yes.
When you spoke about.
Oh, sorry. We'll get you next.
If this is not struck down, would say like the individual states have a right to come and say we're sovereign states and we're not going to comply?
No. Under the supremacy clause of the Constitution, if the mandate is valid federal law, it would trump any state law to the contrary. Now, there were some states that passed anti-mandate statutes, as it were. None of those states seriously thinks that those statutes can trump federal law. The reason they passed those statutes, one reason is symbolic, and another reason has to do with a technical doctrine called standing, which is the question of, can the states bring a challenge to the mandate in court as a violation of the federal Constitution? It's arguably easier for the states to challenge the federal law if they have their own competing law, but there's no credible argument that if the federal law is upheld, then it could nonetheless be trumped by state law. So this is really it.
You talked about the government's argument that health care is different, and you mentioned the emergency room care.
Right.
But my understanding, and I just have a little bit, but is that we're not talking about just catastrophic insurance here. It's not exactly a Cadillac plan, but it's a little bit more than catastrophic coverage. Did the court press really on that argument, and what was his response if they did?
Yeah, that is exactly right. If you take the government's argument for all that it's worth, and you are willing to distinguish the healthcare market, uphold a purchase mandate, address the problem of emergency room cost shifting, what does that get you? It would get you a purchase mandate to buy catastrophic coverage, which is which would solve the problem of emergency room cost shifting. The mandate is not a catastrophic package. In fact, the Affordable Care Act, with narrow, limited exceptions, prohibits insurers from selling catastrophic coverage plans. It has all sorts of prohibitions on both ends of the spectrum. You can't have catastrophic coverage. You can't have Cadillac plan. You have a Cadillac plan subject to a 40% excise tax. So people are forced to buy insurance products that are at government-specified levels. The mandate in practical operation requires what's called a bronze level of coverage on the exchanges that are set up. This is all kind of the technical mumbo-jumbo of the statute. But the bottom line is exactly as you say. It is far more than a catastrophic plan. It encompasses ordinary preventive care that is perfectly predictable in outlay, not beyond the means of most people to pay for, not provided as a matter of entitlement for free. It covers, we now know, contraceptives, right? Does that fit within the emergency room cost shifting paradigm? No, of course not. In terms of how this played out at the argument, Justice Kennedy was probably the justice most ambivalent over the course of the argument. No great surprise on this. He expressed very substantial concerns with the mandate. At one point he said to the Solicitor General, Congress has never before attempted anything remotely like this. Doesn't that give you a high burden of justification? At another point in the argument, he said to the Solicitor General, this statute will fundamentally redefine the relationship between the federal government and its citizens. That sounds like a justice who wants to be with us, at least at the 50,000-foot level. And all of that was very encouraging from our perspective. The competing line of questioning, and this gets back to your point, was at the end of our argument, we were respondents, so we went second. So at the end of the argument, Kennedy says to Mike Carvin, who's up last, my colleague and partner at Jones Day, who argued the mandate on the merits, Kennedy says, well, isn't this different from a lot of the hypotheticals in that the uninsured, the young, healthy uninsured are closer to, more proximate to the problem of emergency room cost shifting than analogous people in hypothetical, you know, the broccoli hypothetical or the car hypothetical or whatever. This is Kennedy's question of, gee, shouldn't I distinguish health insurance for some of the reasons the government says? And Mike gave, I think, very good answer, the legal answer why none of that matters. Perhaps more importantly, for purposes of Justice Kennedy, he gave the sort of softer answer the question on its own terms point that, look, even if that were right, that's an argument at most for the catastrophic plan. This is not that. This is the, you know, bronze prevention, contraception kind of plan. My guess is we will win or lose the case depending on his reaction to that exchange. I don't know for sure, but I think that's really where the analytical pressure point is at this point.
Thanks. I was actually working out in Congress when this bill passed, and the rumor for why the severability clause came out in the Senate was that it was a mistake. Whether that was or wasn't.
Mistake in the House bill?
No, a mistake in the Senate.
Oh, taken out by mistake. I see.
That it was a drafting error, and that by the time they realized it, they sent it over to the House, and the Senate had changed with the addition of Scott Brown, and that our understanding was House leadership, which was Democratic at the time, Speaker Pelosi wanted to put it back in. So, but couldn't because she couldn't change the bill.
You couldn't have reconciled that through
right.
Yeah.
Right. But I think that whole idea of who knows why something came out or why something went in, the legislative process is very mysterious, kind of sets up my question, which is, let's suppose the individual mandate is found to be unconstitutional by the Supreme Court, and then you're saying the question is, does the whole bill go down or just pieces? How does the Supreme Court know which pieces should come out and which should stay in? Because I worked out there, and I can't tell you that it's absolutely true that the Senate made a mistake. Maybe they had a different view. Maybe it was intentional. I don't know. The legislative process is a little like sausage making. How's the Supreme Court supposed to be able to sort it out in a way that respects the role of the legislature, the legislative branch, and the legislative process?
That's interesting. Boy, what a big mistake if that's what happened. Good question on severability. It's really sort of a tricky issue. All right, I want to be fair to the government, and I was in the Bush administration for 8 years and sort of argued the other side. We had, you know, the partial birth abortion statute, right, where the court says, you know, you need a health exception for, you know, 0.001% of cases where the woman may need a particular kind of procedure that's prohibited by the statute, and this statute doesn't have it, and we're going to use that 0.001% case as a justification for striking the statute in its entirety. So, you know, for years I've been on the other side. I totally understand the point that, one plausible theory of the responsible and restrained thing for courts to do is to try to preserve as much as they can of federal statutes. And this was really sort of the challenge for us to come up with the other side of that story. And we said, yes, that is often the case. Other things equal, you might want to preserve as much of a statute as you can. But it's not always the case. And it is not likely to be the case in the context of a statute where there are lots of trades, there are lots of quids and quos. The mandate is obviously a quid pro quo for guaranteed issue and community rating from the perspective of the insurance companies. There's half a $1 trillion in Medicare cuts. Do we think that any Congress would have cut Medicare by $500 billion on its own without everything else, right? There was the Louisiana Purchase, the Cornhusker kickback, right? All of the very grotesquely, all of the graft that may be present to one degree or another in many statutes, but seems to have been present to a much greater degree in this statute. At some point, it just becomes too complicated to unwind. And when you have a statute like that, we said, the more restrained thing to do is to just strike all of it and let Congress start over on a blank slate, rather than what they would have to do here, which is strike very central planks. You take mandate plus guaranteed issue plus community rating is the guts of the statute. They would not be striking a peripheral provision and leaving the core. They would be striking the core and leaving periphery, and it's periphery that there's no reason in the world to think that Congress would have enacted PPACA minus mandate guaranteed issue and community rating. So this is being less deferential to Congress, not more. And severability in this context is not just legally appropriate, but more respectful for Congress. That's our story in a nutshell. And it seemed to get some traction from at least 3 or 4 justices. We'll see. Yes.
Do you think the birth control, freedom of religion issue is going to be headed for the courts anytime soon?
Those are interesting cases. I'm not intimately familiar with them. I would think, based on what little I've read, that the challengers in those cases have a pretty good argument based on the Religious Freedom Restoration Act, which requires Congress to make accommodation for religiously motivated conduct. So if someone has a bona fide objection to paying for other people's abortions, seem to be a pretty good RFRA claim that they have to be let out of that obligation, which they're not. Another interesting question is, how will that controversy affect the court's consideration of this case, if at all? We don't have the religious conscience issues directly present in this case, but one of our dominant themes we tried to stress as much as possible is that all of these doctrines about federalism and enumerated powers and the like, they don't exist just for arid formalism, nor do they exist just to protect the states from the federal government. They exist to protect individual liberty, which is threatened when the federal government becomes too big and too powerful. And boy, I think just having the contraceptive thing kick up right around this time is a great illustration of our point and the threat to individual liberty when the federal government gets too big. So I hope that resonates with them, but it's the conscience challenges are not directly present in our case.
I think we're about to the end of our time, and I'm going to exercise my prerogative to ask the last question. But after the oral arguments, it seemed like the legal commentators and media pundits and law professors were all surprised and shocked that it was taken as seriously as it was, and that there were heated questions coming from the bench. Why do you think that is? Why were they surprised? Were they really surprised? And why did that come out that way?
Look, our opponents have constantly tried to denigrate this case as the product of Tea Party extremists, a political attack on Obama, not a serious legal case, and so on. That's been their narrative. They've tried this at every turn. Reality keeps intruding on this, so it got harder. It was a harder argument to make after we won in the district court. Then we lost this issue in the Sixth Circuit, and we started hearing this again. It then became a harder argument to make after we won in the 11th Circuit before a panel of a majority of whose members were appointed by Democratic presidents. We then lost the issue in the D.C. Circuit, started hearing it again. Then the court sets it for six hours of argument. Again, one would think that should put it to bed, but they have tried this refrain throughout, and I'm not surprised. I'm not surprised that they are feigning. Some probably are surprised. Some probably are feigning surprise. It's just sort of part of their continuing attempt to say that this is not a serious case, and if we win, it's just because there's a conservative court that's out of control. I don't take it too seriously.
Well, thank you for coming. Thank all of you for taking the time out of your schedule to participate. We do have some refreshments, and I hope you'll stay for a brief reception afterwards, have a chance to ask any other questions of Mr. Katsas. There's also a sign-up sheet outside if you didn't get a chance as you were coming in and you want to be sure you're on our email list for future events. We'd encourage you to sign up. So thank you all for coming, and have a good evening.
Thank you. Thank you.